Article 28, tampering with free and fair elections, corruption of the administration of justice, in his conduct while President of the United States, George W. Bush, in violation of his constitutional oath to faithfully execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty under Article 2, Section 3 of the Constitution to take care that the laws be faithfully executed, has both personally and acting through his agents and subordinates conspired to undermine and tamper with the conduct of free and fair elections, and to corrupt the administration of justice by United States attorneys and other employees of the Department of Justice through abuse of the appointment power. Towards this end, the President and the Vice President, both personally and through their agents, did engage in a program of manufacturing false allegations of voting fraud in targeted jurisdictions where the Democratic Party enjoyed an advantage in electoral performance or otherwise was problematic for the President's Republican Party, in order that public confidence in election results favorable to the Democratic Party be undermined. Directed United States attorneys to launch and announce investigations of certain leaders, candidates, and elected officials affiliated with the Democratic Party, at times calculated to cause the most political damage and confusion, most often in the weeks immediately preceding an election, in order that public confidence in the suitability for office of Democratic Party leaders, candidates, and elected officials be undermined. Directed United States attorneys to determine or scale back existing investigations of certain Republican Party leaders, candidates, and elected officials allied with the George Bush administration, and to refuse to pursue new or proposed investigations of certain Republican Party leaders, candidates, and elected officials allied with George Bush's administration, in order that public confidence in the suitability of such Republican Party leaders, candidates, and elected officials be bolstered or restored. Threatened to terminate the employment of the following United States attorneys who refuse to comply with such directives and purposes: David C. Iglesias as U.S. Attorney for the District of New Mexico, Kevin Ryan as U.S. Attorney for the Northern District of California, John L. McKay as U.S. Attorney for the Western District of Washington, Paul K. Charlton as U.S. Attorney for the District of Arizona, Carol C. Lamb as U.S. Attorney for the Southern District of California, Daniel C. Bogdan as U.S. Attorney for the District of Nevada, Margaret M. Chiara as U.S. Attorney for the Western District of Michigan, Todd Graves as U.S. Attorney for the Western District of Missouri, Harry Bud Cummins III as U.S. Attorney for the Eastern District of Arkansas, Thomas M. DiBiagio as U.S. Attorney for the District of Maryland, and Casey Warner as U.S. Attorney for the Southern District of West Virginia. Further, George W. Bush has both personally and acting through his agents and subordinates, together with the Vice President, conspired to obstruct the lawful congressional investigation of these dismissals of United States attorneys and the related scheme to undermine and tamper with the conduct of free and fair elections and to corrupt the administration of justice. Contrary to his oath faithfully to execute the office of President of the United States, and to the best of his ability preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed, George W. Bush has, without lawful cause or excuse, directed not to appear before the Committee on the Judiciary of the House of Representatives certain witnesses summoned by duly authorized subpoenas issued by that committee on June 13th, 2007. In refusing to permit the testimony of these witnesses, George W. Bush, substituting his judgment as to what testimony was necessary for the inquiry, interposed the powers of the presidency against the lawful subpoenas of the House of Representatives, thereby assuming to himself functions and judgments necessary to the exercise of the checking and balancing power of oversight vested in the House of Representatives. Further, the President has, both personally and acting through his agents and subordinates, together with the Vice President, directed the United States Attorney for the District of Columbia to decline to prosecute for contempt of Congress the aforementioned witnesses, Joshua B. Bolton and Harriet E. Myers, despite the obligation to do so as established by statute. That's in 2 U.S.C. Section 194. And pursuant to the direction of the United States House of Representatives as embodied in its resolution H. Res. 982 of February 14, 2008. In all these actions, President George W. Bush has acted in a manner contrary to his trust as President and subversive of constitutional government, to the prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, President George W. Bush, by such conduct, is guilty of an impeachable offense warranting removal from office.